Hey, good day to you. This is Stan Prochowski with the Prochowski Law Firm with another legal tip for you. I get a lot of phone calls in my office from people asking questions about landlord and tenant relationships. So I thought I'd touch on that a little bit. In most counties in Tennessee, they have what is known as the Tennessee Landlord and Tenant Act. It was enacted in 1975. Problem is that act only applies to counties that have a population of 68,000 or more, or if they're accepted by private act. Giles County not being one of them. But a lot of the provisions of that act are still in full force and effect in Giles County. They just come in under what we call the common law. So I'm going to go over some of the basics, the subject of what most people call about. First thing are rental agreements. Whenever you rent a place, an apartment, a duplex, or even a house, whenever you enter a rental agreement, always get a written contract and always keep a copy of that contract. That is a binding contract and it expressly shows the terms and conditions of the rental. Now, if you don't keep a contract or you don't have a contract, you still have an agreement, but it's an oral agreement, and oral agreements are much harder to prove what the terms and conditions are because they're not written down. Another topic that I get asked about a lot are security deposits. Now, if a landlord requires that he wants a security deposit to be paid in advance, that deposit must be kept in a special account for that very purpose. And he also has to let you know the location of where that account is. Now, after you move out, the landlord is required within just a few days to go into the apartment, inspect it, make a list of damages, make a report on what he intends to use that security deposit to pay for. That report has to be given to you, and you have to be given notice of it so that you can go in and inspect to verify the accuracy of it. If you disagree, the tenant can sue in court for the inconsistencies. Another thing I get asked a lot about is access by the landlord to the property. The question I get asked is, can the landlord just come into my property and look around? Well, the answer is pretty much no. You're entitled to what we call quiet enjoyment of the rental property. However, what's required of the tenant is that he not withhold reasonable access to the landlord. Now, when we say reasonable access, it has to be for a specific purpose. Typically, that is for the landlord to come in to inspect repairs or damages that he has to take care of, services that have to be applied, or he's allowed to have access with your consent to show the property off to future prospective tenants. So, a landlord just simply cannot come in and to harass you or just constantly ask to come in and see what you're doing or what's going on. If that happens, you are perfectly within your rights as a tenant to deny access. You are, as I said, entitled to quiet enjoyment of the rental property. Now, the state of Tennessee puts out a little brochure. It looks like this, but if you want to get a copy of it, you can download it on the internet. It's at www.tn.gov/consumer. So again, that's www.tn.gov/consumer. Well, there you have it, the Tennessee Landlord and Tenant Act of 1975 and the common law rights of landlord and tenants. Another legal tip for you from the Prochowski Law Firm. I'm Stan Prochowski, and I'll see you next time with another legal tip.